All rise. We will away.
Good afternoon, everybody, or is it good evening? You can hear me, everybody? Please sit, you may sit down.
Please be seated.
Please be seated. The appeals chamber will now hear the prosecution's response.
Then
For the prosecution, you have 1 hour for this part of the session.
Apologies, Madam Presiding Judge. Mr. Mladić has stood to his feet, and I believe he has something he'd like to say at this point.
Your Honor, this is the 9th hour. I've been here for 9 hours now. As far as tomorrow is concerned, I would like to ask you for us to follow the prior procedure. We could have a short break, not 1 hour. I spend 4 hours in a room, an isolation room. I can't put up with this sort of thing. I won't be able to put up with it tomorrow. I'm sorry about this.
As I understand, the 1 hour break we have is to facilitate fumigation of the courtroom. And I would therefore invite the registry to respond to that, whether it's possible to make the breaks shorter.
Madam Presiding Judge, I will take that on board and alert my colleagues to it and revert to the chamber before the end of the session. Thank you.
Thank you. Now, counsel for the prosecution, you may proceed.
Thank you, Madam Presiding Judge. Your Honors, Ratko Mladić is not a war hero. He is a war criminal. He abused his vast military power to deliberately target the civilian population, destroying lives, families, and communities. Mladić was properly convicted and sentenced after a fair trial for some of the most heinous crimes of the 20th century. And during the trial, which lasted more than 3.5 years, the chamber received evidence from nearly 600 witnesses and admitted almost 10,000 exhibits. And after comprehensively assessing the totality of this extensive evidentiary record, and with full respect for the burden of proof and the criminal standard of beyond reasonable doubt, the chamber found Mladić guilty of war crimes and crimes against humanity, as well as genocide in Srebrenica. His crimes affected hundreds of thousands of people, with long-term effects that are still felt today. And for the extreme gravity and scale of his crimes, Mladić was properly sentenced to life imprisonment. In his appeal, Mladić calls into question vast portions of the trial judgment, seeking full exoneration, a retrial, or a reduction in his sentence. But none of Mladić's grounds of appeal show any error warranting Your Honor's appellate intervention. On appeal, it is not enough for Mladić to say that he wanted a different outcome. Instead, he bears the burden of showing errors in the trial judgment that meet the well-established standards of review on appeal. He cannot do so. He does not even come close. For example, many of Mladić's arguments seek to trigger review of the entire trial judgment based on what he calls illustrative examples, impermissibly asking Your Honors to figure out if his arguments could apply to other unspecified findings or other unspecified incidents. Throughout his appeal, he misstates the record, the trial judgment, and the jurisprudence. He improperly reiterates failed trial arguments without engaging in the trial chamber's reasons for rejecting them, and he repeatedly claims that the trial chamber disregarded evidence that the trial chamber clearly considered in the trial judgment. These flawed arguments show no error. They cannot even come close, and many warrant summary dismissal. Mladić's appeal should be dismissed in its totality. I'll begin the prosecution's response today by addressing Mladić's arguments concerning the overarching joint criminal enterprise. That's ground 3. And then my colleague, Ms. Goy, will make submissions on ground 4, Sarajevo. And tomorrow, I will address Srebrenica, ground 5, and Ms. Goy will conclude by responding to Mladić's remaining grounds of appeal. Starting with ground 3, concerning the so-called overarching joint criminal enterprise, the purpose of which was to permanently remove non-Serbs from Serb-claimed municipalities in Bosnia-Herzegovina through persecution, extermination, murder, deportation, and forcible transfer. The trial chamber reasonably concluded that at the latest, when Mladić became the commander of the VRS main staff on the 12th of May, 1992, he joined with other Bosnian Serb leaders in pursuit of this common goal of ridding entire municipalities of non-Serbs. That objective was to be achieved, quote, by whatever means, paragraph 4222. Your Honors, in the face of the extensive evidence proving his responsibility, Mladić's appeal is manifestly deficient. He focuses primarily on the chamber's weighing of individual pieces of evidence. He argues that the chamber could have looked at this evidence in a different way to reach an acquittal. But nowhere does he explain how his proposed approach to these individual items of evidence, taken in isolation, would have impacted the chamber's conclusions. And nowhere does he address the chamber's analysis of this same evidence and these same arguments at trial. And nowhere does he show that the trial chamber's findings were unreasonable. This does not reach the appellate standard. Appeals chambers have repeatedly emphasized the margin of deference afforded to the findings of fact by a trial chamber. Mladić might not like these findings, but nowhere in his appeal does he give Your Honors a reason to change them. I'd like to begin by highlighting some of the chamber's conclusions that led it to find that this joint criminal enterprise existed, and addressing the challenges to this conclusion, before turning to Mladić's significant contribution, and finally to his mens rea. Your Honors, there is no doubt that an overarching joint criminal enterprise existed, which Mladić joined in 1992. Mladić knew, even before he joined, that violent takeovers, which transformed previously multi-ethnic municipalities into Serb-only municipalities, had already begun. In 1991, preparations began to establish separate Serb political institutions at the republic and municipal levels. And pursuant to the instructions of the Bosnian Serb president, Radovan Karadzic, Bosnian Serb authorities created Serbian crisis staffs and mobilized Serbian police and territorial defense units in each of the municipalities. Their aim was to assert Serb control at the municipal level by military means if necessary. In municipalities where Serbs were in the majority, but also in municipalities where Serbs were in a minority. And the chamber reasonably concluded that Mladić shared the intent to achieve the common purpose by, at the latest, 12th of May 1992, when he was handpicked by President Karadzic to lead the Bosnian Serb army. On his very first day in command, Mladić addressed the Bosnian Serb Assembly, calling for a strong, disciplined army with a robust chain of command. He was capable of influencing the Bosnian Serb leadership while being ultimately subject to it. There is no inconsistency between the two. During this assembly meeting on the 12th of May, 1992, the Bosnian Serb leadership agreed that the objective of ethnic separation should be achieved by, quote, whatever means, unquote, and that care should be taken to hide this truth. The Bosnian Serb leadership agreed with Mladić's proposition that their plan had to be guarded as their deepest secret. Your Honors, in reaching this conclusion, the Chamber carefully considered the statements of all of the participants in this meeting and the context of the meeting. My learned colleague cannot show error in the trial judgment by highlighting a single excerpt out of context. For the Chamber's finding, I would refer you, Honors, to the trial judgment at paragraph 4222. As the Bosnian Serbs took power in more and more of the municipalities, Mladić's VRS soldiers worked together with other Serb forces under the control of other JCE members to commit crimes. These forces included the police units of the Bosnian Serb Military of the Interior, referred to in the judgment as the MUP, and the territorial defense units of the Ministry of Defense, called the TO, and the Serb paramilitary units under the command of the VRS or the MUP, and members of regional and municipal authorities. Members of the JCE, including Mladić, used the forces under their control as tools to commit crimes in the municipalities, as found by the trial chamber at paragraph 4239. And let me pause here, Your Honors, to clear up two legal issues that were raised this morning. First, with regard to tools. The law does not require an agreement between the tools and the JCE members. My learned friend accused the prosecution of misleading the court by suggesting that any link was sufficient. This is not the prosecution's position. The Brjanin appeals judgment explains that JCE members can use tools to carry out the actus reus of the crimes. The link between the tools and the JCE member who's using them is a factual matter to be assessed on a case-by-case basis. And I would refer Your Honors to paragraphs 410 to 413 of the Brjanin appeals judgment. subsequent jurisprudence has clarified some of the situations that satisfy this test so that the crimes of the tools can be attributed to the JCE members. For example, when the tool belongs to a hierarchical organization, such as the military or police, that is controlled by a JCE member. And I would refer you, for example, to the Mladić appeals judgment at paragraph 187 to 188. The Brajanin appeals judgment, paragraph 419, was cited this morning for the proposition that there needs to be an agreement between the tools and the JCE member. But this paragraph plainly says the opposite. It says that the trial chamber in that case was in error when it required such an agreement between the JCE members and the tools. The second legal issue that I'd like to address concerns the relevance of evidence outside the temporal scope of the joint criminal enterprise. And here, Your Honors, we need to distinguish on the one hand, the timing of the contribution, which must coincide with the mens rea, and must generally be within the temporal scope of the joint criminal enterprise as charged. And we distinguish that with, on the other hand, the evidence used to prove that actus reus and mens rea, which is not restricted in the same way. The trial chamber was entitled to rely on evidence concerning events before and after the joint criminal enterprise to establish both the actus reus and the mens rea. And the case law shows that the trial chamber's approach was the correct one. And I would refer Your Honors to the appeals chamber's 18 April 2002 decision in the Slobodan Milosevic case, and to the Perlich appeals judgment, paragraph 711. The trial chamber correctly and reasonably found that together, the JCE members and the tools working under them unleashed unimaginable violence, creating an environment so coercive that tens of thousands of non-Serbs were left with no choice but to leave the territory. Bosnian Muslims and Croats were fired from jobs, subjected to other discriminatory measures. In Prijedor, those who weren't expelled or sent to the camps were required to wear white armbands to distinguish themselves from the Serb population. On the radio, propaganda spread and encouraged ethnic hatred and discrimination. Mladić's soldiers, working with other Serb forces, attacked predominantly non-Serb towns and neighborhoods. They indiscriminately shelled civilian areas. In a single attack in Prijedor, over 800 inhabitants were murdered. Serb forces were cold-blooded and methodical, reading names off lists, executing women, old men, children, forcing victims to jump from bridges and then shooting them to be sure that they were dead. According to a witness, the river was full of corpses. Muslims and Croats were rounded up, families were separated. Non-Serbs were stripped of their valuables, forced to hand over their property. Convoys of buses and trains were organized by the Bosnian Serb authorities to drive tens of thousands of men, women, and children out of Bosnian Serb claimed territory. Human beings, torn from their homes and communities, fearing for their lives, forced onto buses and convoys guarded by armed soldiers, suffocating in airless refrigerator trucks crammed onto freight trains. The Bosnian Serb forces intended that they would never return, They burnt Muslim and Croat places of worship and destroyed non-Serb homes and businesses. Serb property was spared. The trial chamber found that across the Serb claim municipalities, non-Serb civilians, male and female, young and old, were also detained en masse. In-transit and detention camps established throughout the municipalities, often with the support of the VRS. Detention camps whose names are synonymous with human suffering: Batkovic, Manjača, Omarska, Karaterm, and Ternopile, Kapidom, Foča, and other smaller makeshift prisons in factories, schools, sports facilities, police stations, and other public buildings. And over the course of 1992, non-Serb civilians were arrested and detained throughout this camp system in appalling conditions. Overcrowded, unsanitary, lacking food, water, and medical care. Many were raped and sexually assaulted. Women and men, girls as young as 12 and 13. Many were beaten and tortured. Many were forced to do dangerous labor and used as human shields. Many died from starvation and abuse, and many were executed. Their bodies dumped into mass graves, buried and reburied to hide their murders. In one of the most notorious camp massacres, VRS soldiers gassed and then slaughtered 200 detainees with a single machine gun while the guards sang songs. And I'd refer you to paragraph 1121 of the trial judgment. While this event stands out for its horrific facts, it is by no means unique. Prisoners in these camps face death every day. And for the vast majority of the detainees, their only crime was their ethnicity. And this is what the realization of the common criminal purpose looked like. This is what it had to look like to achieve their goal, which was a complete redrawing of the regional map. Mass suffering in the name of ethnic ideology. And this is what Mladić signed up for when he joined the Joint Criminal Enterprise in May of 1992. A joint criminal enterprise whose objective was to permanently remove non-Serbs from the charged municipalities by whatever means necessary. The JCE's campaign was as brutal as it was successful. By the end of 1992, most of the territory claimed by Mladić and the other JCE members had been rendered ethnically pure Serb territory. In 5 of these municipalities, the crimes committed were so extreme that the trial chamber found that the local perpetrators, most under Mladić's direct control, intended to destroy those parts of the Bosnian Muslim group. Paragraph 3526. And Mladić and the other JCE members continued this violent ethnic cleansing campaign until 1995 in order to cleanse a few remaining Muslim enclaves in eastern Bosnia. This, Your Honors, is the basis for the trial chamber's conclusion that there was a joint criminal enterprise. This intense pattern of violence committed by soldiers and others under Mladić's command, working hand in hand with police, territorial defense, paramilitaries, and administrative authorities. And it's against this background that Mladić claims that there wasn't a JCE, that he wasn't a member, because he purportedly acted to protect non-Serbs. For example, because a limited number of non-Serbs remained in one municipality, or because of a couple of entries in his notebook about purported constraints that his army experienced, or because of supposed good deeds he ordered, which, as we've explained in our response brief at paragraphs 54 to 60, were neither relevant nor particularly good. All of his arguments are based on the trial chamber's treatment of specific exhibits, but he fails to show any error in the chamber's assessment. In short, Your Honors, the limited evidence he relies on cannot establish the positive attitude that he claims to have had towards non-Serbs, and the incalculable suffering of the victims for 3.5 years across the 14 municipalities convincingly proves the opposite. Your Honors, there was an overarching joint criminal enterprise in the municipalities, and the concerted actions of Mladić's military, along with the other Bosnian Serb organs, proves it. Mladić shows no error in the chamber's conclusion. This brings me, Your Honors, to his challenges concerning the chamber's findings on his JCE contribution. The trial chamber found that Mladić's contributions to the overarching joint criminal enterprise were not just significant, they were instrumental. It concluded that without his contributions, the crimes would not have been committed as they were. And in reaching this conclusion, the trial chamber considered Mladić's many contributions to this goal. The summary and conclusion can be found at paragraphs 4611 and 4612 of the judgment. First and foremost, Mladić was in command and control of the VRS, members of which were found to have been involved in a vast array of crimes from 1992 to 1995. Mladić's contributions, analyzed extensively in Chapter 9.3 of the trial judgment, go far beyond the routine duties of a legitimate commander. Mladić raises 3 main arguments against the trial chamber's findings on his JCE contribution, all of which claim that the trial chamber failed to give sufficient weight to his preferred evidence. Again, without demonstrating error, without engaging in the chamber's treatment of that evidence, and without showing that no reasonable trier of fact could have made that finding. Before I address the 3 arguments, I want to focus for a moment on what he does not challenge. Because Mladić only challenges a few of the JCE contributions found by the chamber. But even if these challenged contributions were removed, his remaining contributions would still have been sufficiently significant to meet the legal requirements for a JCE contribution, especially when you consider, as the trial chamber did at paragraph 4612, that many of the crimes were perpetrated by the VRS. He does not challenge, for example, the chamber's conclusion that he contributed to the JCE by establishing and maintaining the VRS, including by seeking assistance from Serbia in meeting the ongoing needs for personnel, equipment, and ammunition. He does not challenge the finding that he contributed by addressing the Bosnian Serb Assembly and advising the political leadership. He does not challenge the chamber's finding that he contributed by introducing and maintaining a propaganda machinery aimed at spreading anti-Muslim and anti-Croat fear and hatred. And he does not challenge that he contributed through deliberately misleading the international community about the crimes, or the Chamber's conclusion that he contributed by severely restricting humanitarian aid in the later part of the JCE. These findings that Mladić does not challenge would still amount to a significant contribution. Turning to the challenges he does make. His first argument concerns the resubordination of the MUP police forces to the VRS. Mladić claims that he lacked general command and control over the police, and so crimes committed by the police could not form part of his significant contribution. Now, the Chamber did make general findings that the police were in some instances resubordinated to, and in other instances cooperating with, the VRS. But the Chamber's specific findings on Mladić's own contribution to the JCE were much more narrowly focused and conservative. The only contribution based directly on crimes committed by the police concerned the police in Menyacha camp, one detention camp in Banja Luka municipality. And I would refer your honors to this specific finding in paragraph 4404 of the judgment. Similarly, Mladić's contribution through failure to prevent and punish crimes was expressly limited to crimes of the VRS and the other Serb forces discussed in chapter 9.3.4. And with regard to the police, this was again limited to Menyacha camp. That's at paragraph 4544. In other places, the crimes committed by the police are attributed to Mladić through the other JCE members, but they are not counted as Mladić's personal contribution to the joint criminal enterprise. So Mladić's arguments about general command and control over the police is irrelevant to the question of Mladić's personal contribution. Likewise, Your Honor, the crimes of the paramilitaries were only specifically counted as Mladić's contribution in those couple of situations where the paramilitary group was specifically found to be under Mladić's command and control. And I would refer you to paragraphs 4402 to 4403, and again 4544. Turning to his second argument, Mladić claims that the trial chamber failed to give sufficient weight to evidence that his lack of professional subordinates affected his ability to command the VRS. Even assuming this were true, he never explains how inexperience would deprive him of effective command and control. But many of the VRS soldiers under his command were not inexperienced. The trial chamber detailed how the VRS was formed, drawing on the ranks of the 90,000 experienced soldiers of the JNA, the Yugoslavian People's Army, who were Bosnian Serbs. The trial chamber found at paragraph 3747 that many of the commands and units of the JNA simply renamed themselves units of the VRS. So the VRS did not start off with just Mladić and a few officers, as we heard this morning. For example, the JNA 5th Corps simply became the VRS 1st Krajina Corps and was established between the 12th and 20th of May, 1992. That's trial judgment, paragraph 147. It was the largest VRS corps with a zone of responsibility including half of the municipalities in the Bosnian Serb Republic. Of course, the trial chamber considered evidence of actual indiscipline. This was already factored into the trial chamber's consideration of the strong evidence of Mladić's very high level of command and control over his subordinates. This included evidence from Mladić's own subordinates, including defense witnesses proving that Mladić was in command, was respected as a leader, and that his orders were strictly adhered to. Mladić's third argument is that the trial chamber failed to give sufficient weight to evidence that he did not know of specific crimes, and therefore his failure to punish the perpetrators should not be counted as JCE contributions. As we point out in our response brief, some of the documents he relies on actually informed Mladić the crimes were being committed by his subordinates. One notes concerns of the ICRC about detention facilities, and the other reports a massacre of detainees. But even if this evidence could be read in his favor, it doesn't get his argument anywhere. The trial chamber did not find that he knew of every incident because it did not need to. The evidence was sufficient for the trial chamber to conclude more generally that Mladić knew that crimes against humanity and war crimes were being committed against Bosnian Muslims and Croats in the municipalities and in the detention facilities. To reach this conclusion, the chamber reasonably considered the extensive evidence concerning Mladić's hands-on command, as well as the fact that the crimes in question were widely acknowledged and reported by the international media and the United Nations. This was sufficient to trigger his superior responsibility to prevent and punish. Yet the chamber found that it did not receive any evidence of any Bosnian Serb being prosecuted for war crimes committed against non-Serbs between the 12th of May 1992 and the 30th of November 1995. That's paragraph 4545. Instead, Mladić chose to cover up the crimes and to promote and congratulate VRS officers involved in atrocities. None of Mladić's three actus reus challenges show any error in the trial chamber's conclusion. Turning finally, Your Honors, to Mladić's shared intent. Mladić challenges the mens rea analysis on the basis of methodology and because it's based on circumstantial evidence. First, there was nothing wrong with the chamber's methodology. The chamber's approach was fully consistent with the logic set out in the Stanisic-Samatovic appeals judgment. And I should clarify here that the Stanisic and Samatovic judgment does not stand for the proposition that trial chambers must, in every instance, follow a particular order of analysis. Its holding is more narrow, that the trial chamber in that case erred in finding that the mens rea element was not met without having first adjudicated the other elements of joint criminal enterprise responsibility. But in the Mladić case, the trial chamber did follow the order of presentation recommended in the Stanisic-Samatovic judgment. It set out the existence and scope of the JCE and whether the accused acts contributed to that purpose before determining whether he shared the intent. And there is no reason to think that the trial chamber's findings are in any way tainted by a purported mix-up between the actus reus and the mens rea findings. This argument rests on the idea that a trial judgment is a linear document that records a sequential deliberation on each topic in a particular order. But as the case law has repeatedly emphasized, trial judgments must be read as a whole. And I would refer you, for example, to the Sayanovich appeals judgment at paragraph 306. But in this case, there was no mix-up, and there is no taint. Mladić cannot identify a single clear example of this problem. What his examples do show is the chamber using language that is consistent with its mens rea analysis in the contributions chapter, and cross-referencing in the contributions chapter to the evidence reviewed in the mens rea chapter. There is simply nothing wrong with this, as Mladić acknowledges at paragraph 288 of his appeals brief. There is nothing improper about a chamber relying on the same underlying evidence or factual findings to draw conclusions on different aspects of the case. Mladić's second argument concerns the chamber's reliance on circumstantial evidence to make intent findings in particular. In Mladić's view, the chamber should have preferred what he calls direct evidence of his mens rea. But this argument is wrong on two levels. First, there is no legal support for his preference for direct evidence, not in relation to mens rea, but also not in relation to the many other instances that he raises, where he raises this distinction throughout the appeal. Criminal intent can be, and absent a confession usually is, proven primarily through circumstantial evidence. And in his reply at paragraph 64, Mladić denies that he's arguing that direct evidence is inherently more valuable than circumstantial evidence. Yet he repeatedly claims that direct evidence is automatically stronger. And my learned colleague submitted this morning that circumstantial evidence cannot outweigh direct evidence. This is incorrect. The tribunal's jurisprudence is clear. There is no rule that a chamber should prefer direct evidence. The only rule is that a chamber has to consider the evidence in its totality, including both the direct and the circumstantial evidence. And this is because the probative value of evidence is determined by looking at it within the totality of the evidence in the case, not by labeling it direct or circumstantial. And this is what the trial chamber did in this case. It looked at the totality of the evidence before concluding at paragraph 4688 that Mladić shared the common purpose and intended the underlying crimes. And the evidence of Mladić's mens rea was overwhelming. It included his expressions of commitment to an ethnically pure Serb republic, his statements indicating that he was willing to disobey the laws of war, his fomenting of fear and hatred towards Muslims and Croats, his repeated use of derogatory terms for Bosnian Muslims and Croats, such as Turks, Balijas, and Ustašas. And of course, his long-standing instrumental contributions to the common purpose with full knowledge of the crimes committed in its pursuit. Paragraphs 4685 and 4686. Your Honors, the jurisprudence is also clear that on appeal, the same standard of review for factual findings, the reasonableness standard, applies whether the evidence is direct or circumstantial. And I would refer you, for example, to the Galich Appeals Judgment, paragraph 9. Mladić cannot meet his burden by claiming that his preferred evidence is better or should have been given more weight because it was supposedly direct rather than circumstantial. Nor can he succeed on appeal by proposing different inferences than the trial chamber based on isolated parts of the evidence. Instead, Your Honors, to show error, he must address the totality of the evidence and the chamber's analysis of the whole evidentiary record. He did not do that in his written briefs, and he has not done that today. Turning to the second point, concerning the direct and probative evidence that Mladić repeatedly claims was disregarded. It was not really any of those things. It wasn't direct, it wasn't probative, and it wasn't disregarded. Much of the evidence that he labels as direct is actually circumstantial evidence of his intent. For example, at paragraph 309 of his appeals brief, he calls the paramilitary orders direct. But what he's actually seeking is an inference that reflects his disapproval of crimes. Technically speaking, this makes the evidence circumstantial for the point that he's trying to make with it. But the evidence he complains about does not have significant probative value in light of the totality of the evidence. For example, evidence that Mladić occasionally ordered adherence to the Geneva Conventions weighs very little when compared with the powerful evidence showing that he knew that his troops were committing war crimes and crimes against humanity with his approval and support. The trial chamber was entitled to conclude that these orders did not demonstrate his true intent. In any event, all of this evidence was analyzed in the trial judgment. None of it was disregarded. When the evidence was found to be relevant, it was addressed by the chamber in its reasoning. Mladić cannot show error by complaining that the trial chamber failed to specifically refer in the mens rea section to irrelevant evidence or to evidence that it found to be unreliable or inaccurate. To conclude on ground 3, Your Honors, the chamber reasonably found, on the totality of the evidence in this case, that Mladić was a member of the overarching joint criminal enterprise, that his contributions were instrumental, and that he shared the intent to commit the crimes of persecution, extermination, murder, deportation, and forcible transfer. Mladić's deficient arguments show no error. Your Honors, ground 3 should be dismissed. Madam Presiding Judge, we're at your disposal. We can start with the Sarajevo response right now for 10 minutes. We believe that we can get through most of it within the next 10 minutes. Do we have sufficient time, or would you rather pause at this stage?
I think you have 10 minutes. My time here is 6:19, and we're supposed to stop at 6:30.
Okay, then I'm passing the floor to my colleague, Ms. Goy. Thank you very much for your attention.
Good afternoon, Your Honours. I will respond to ground 4 and thereby limit the prosecution's submission to the question of jurisdiction over the crime of terror, since this was the only part of ground 4 that was addressed in oral argument today. The ICTY has jurisdiction over the crime of terror. The prohibition of terror under customary international law is not disputed by Mladić. But the criminalization of terror, the individual criminal responsibility for the crime of terror, also form part of customary international law at the time of the events. The infliction of terror upon the civilian population at the time of the Sarajevo events has been adjudicated in a number of cases before the ICTY and the mechanism. In Galić, the ICTY trial chamber examined the criminal responsibility for the crime of terror under customary international law, but ultimately relied on an agreement between the parties to the conflict in which the parties agreed to apply certain rules of international humanitarian law, including the prohibition of terror, and agreed to punish those responsible for violating the rules. That's the Galić trial judgment, paragraphs 124 and 127. The appeals chamber in Galić found the criminalization of terror based on customary international law after a careful analysis. That's the Galić appeal judgment, paragraph 98. This holding was confirmed by the ICTY appeals chamber in the Dragomir Milosevic case, in the last ICTY appeals judgment in Perlic et al., and by the mechanism appeals chamber in the Karadzic case. Mladić fails to provide cogent reasons to depart from this settled jurisprudence. Rather, he complains that there was insufficient state practice, but ignores that the Galić appeals chamber did not only rely on national laws. The Galić appeals chamber also pointed out in paragraph 93 of the appeal judgment that terror as a war crime was first referred to in a report published in 1919 by the Commission on Responsibilities. The Commission on Responsibilities was created by the Peace Conference of Paris to inquire into breaches of the laws and customs of war committed by Germany and its allies during the First World War. Moreover, the statute of the ICTR confirmed the customary international nature of terror, even for non-international armed conflicts. It explicitly contains acts of terrorism. As the ICTY appeals chamber in Celebici noted, when the Security Council established the ICTR, it was not creating new law, but was codifying existing customary rules. That's the Celebici appeal judgment, paragraph 170. This shows that the crime of terror formed part of customary international law by the time Mladić committed terror in Sarajevo. And importantly, Mladić himself could foresee that his conduct in Sarajevo could lead to a conviction for the crime of terror. He could foresee this not only based on the international sources I mentioned, but also because terror was criminalized in the 1976 Yugoslav Criminal Code. Mladić is correct that this Yugoslav Criminal Code did not define terror, but it did criminalize subjecting the civilian population to terror, quote, in violation of rules of international law effective at the time of war, end quote. And these rules on international law effective at the time of war were set out at the time of the events in Sarajevo in the 1988 Yugoslav military manual. This military manual explicitly said that attacking civilians for the purpose of terrorizing them is explicitly prohibited. That's on page 29, paragraph 47 of the military manual that Your Honors will find in the Book of Authorities to the Prosecution Response Brief. So read together, the criminal provision on terror and the 1988 military manual made criminal responsibility for terror sufficiently foreseeable to Mladić, a career officer in the Yugoslav army, the JNA, who had served for almost 27 years before he became the commander of the VRS main staff on 12 May 92. This conclusion is supported by the ICTY Appeals Chamber in Galić. There, the Appeals Chamber held that the same combination of provisions, the Yugoslav Criminal Code and the military manual, was relevant to the foreseeability of incurring criminal responsibility for terror for Mladić's subordinate, General Galić. That's the Galić Appeal Judgment, paragraph 96. Your Honors, the ICTY had jurisdiction over the crime of terror, and ground 4 should be dismissed. Your Honors, might this be an opportune moment to break for the day?
You have 4 minutes, but if you think this is the right time to break, we
think
can
so.
adjourn.
Because
Very
we would
well.
start a new ground, and that might be better to start tomorrow. Thank you, Your Honor.
Very well. Now the appeals chamber will adjourn to tomorrow and start at 9:30 for the prosecution to continue their reply. All rise.
All right, we will be.